Okay, hi everyone. Welcome to our session today talking about developments in Connecticut employment law, or welcome back if you've already joined us for the first two sessions on Maine and Massachusetts. We're so excited to have you here today. As you all likely know, we and the Labor and Employment Group do a update every month and have been doing this now for at least since I've been here, Tani. I don't know if it's gone on before that, but we're really excited to have you here for our first installment, and please stay tuned for forthcoming sessions.
Yeah, absolutely. So I'll just join Emily in welcoming everyone here today. This is our second annual virtual annual update. In the past, we've done it always in person, but considering health and safety concerns, another virtual year for us. So every month you can expect to have a new presentation. Next month, Elizabeth Johnston and Elizabeth Smith will be presenting on romance and relationships in the workplace. And that presentation is occurring on February 17th at 9:30. The materials for today's presentation are available through the link in the chat. And additionally, the presentation itself is being recorded, and a copy of that recording as well as the slides will be sent out by email after the live presentation. Throughout the course of the presentation, you're welcome to use the chat function to ask questions concerning anything that you're unclear about or need additional information on. And with that, I will turn it back over to Emily to get us started on talking about the most recent developments in Connecticut labor and employment law.
Great, thank you, Tani. So the first law that we are going to dig into today is the Connecticut Paid Family Leave Law. Now, I know that everyone on the call is likely familiar with this one to a certain extent. It was first passed in 2019 and employee contributions started last year. But there's still a lot to go over, and I'm sure your organizations are just kind of diving into administering that program. So we'll start with this one. So before I forget, I wanted to make sure I made reference to the Connecticut Family Leave Authority website. I'm sure that you all have had a chance to kind of go and check that out, but I personally think it's been pretty informative, and they've done a good job of keeping it up to date. So that's a really great reference point as you're getting started on administering this program. So first, who is covered under the Connecticut Paid Family Leave? All employers are covered. Employees are covered who have earned at least $2,325 during the highest earning quarter in the first 5 of the last 5 quarters, and who are employed by a covered employer, or who have been employed by a covered employer in the previous 12 weeks, or employees who opt in as self-employed. What you'll note here is that employees do not need to be based in Connecticut to apply for this leave. They just need to work for a Connecticut employer to apply for the benefit.
In order to receive the leave, however, they're going to have had to have paid into the system, into the program itself. And it's important to understand that, see this number here in coverage where it says at least, 2,325 during the highest earning quarter in the first 4 of the last 5 quarters. The good news is that you as an employer are not going to be asked to figure this out. This is something that the department itself is going to determine, so you don't have to worry about making this determination. And actually, in communicating coverage to employees, we recommend telling employees that it's outside of the scope of what we determine. The department itself will determine coverage.
Thank you, Tani. Yeah, that's a really great point. Thankfully, with this law, although there are elements of it that are complex, the administration and decisions on who receives benefits is really all determined by that state agency, which is great. So for leave reasons, you're going to see the same types of reasons that you would expect with an FMLA type law. The only thing I would want to point out here is that it is a broad definition of a family member that you're going to see in the statute. So it includes, spouse, sibling, child, grandparents, grandchildren. It also includes an individual related by blood or with a close association that is the equivalent of a family relationship. So that's just good to keep in mind. So looking towards the benefits that are available under the statute, benefits are now payable. That was effective January 1st of this year. And the benefit is going to be 12 weeks of pay in a 12-month period. Exceptions to this are going to include 12 days in the 12-month period that can be used as income replacement for family violence leave, and up to 2 additional weeks of income replacement during the leave for incapacity during pregnancy. So now remember that in addition to the Connecticut paid leave, you also have kind of operating to the side the Connecticut FMLA. So, some exceptions there might be the military caregiver leave. Under Connecticut FMLA, you can be eligible for 26 weeks in a 12-month period if you're applying for that type of a leave.
Something to add here, and this is where we're seeing the most number of questions from employers. And it's unfortunately because there's currently a gap in communication, at least between employers and the department itself, is for our employees who have taken leave benefits in 2021. So let's say that there was a pregnancy and the individual was already out on FMLA leave and they went out on leave in November. And maybe you either had FMLA leave because you were required to under the statute, or you simply provided it in addition to the other benefits you provide employees. Now, on the form that employees are filling out and the form that employers are asked to complete regarding the leave, there's no space to explain previous time that's already been taken. So while the Connecticut Department of Paid Family Medical Leave is indicating that everyone's on the same page, that you're only entitled to 12 weeks in a 12-month period. Right now on the application, there's no way to identify previous time that has been taken, which is then resulting in the department sending notices to employees indicating that they're entitled to 12 weeks of paid leave. Now, this is contrary to many of the employers who have already provided multiple either weeks or months of leave. And now employees are improperly being told that in addition to what they've already taken, they're getting this 12 weeks. And it's important then to contact the department and to have a discussion and dialogue and help them understand, in fact, X, Y, and Z number of weeks have already been taken. We use a rolling calendar year in order to determine eligibility and have that discussion. But that over the course of the next year is likely going to be one of the toughest things. And granted, this is only going to happen in 2022 because following that period of time, all the records are going to be easier to communicate. And the program itself will identify past leave taken, but that's one of the places we're getting the most number of questions from employers right now. Sorry, Emily, you can jump back into it, but I just wanted people to be aware that if they are experiencing that issue, they are not alone. That we've had a multitude of other clients who are experiencing that same issue.
No, thank you, Tani. That's a great point. Yeah, so, in terms of the benefit amount, the benefits are capped at 60 times the Connecticut minimum wage. So it depends on what the worker is making to determine what they're going to be eligible to receive in terms of payment when they utilize this benefit. So for example, if the employee's wages are less than or equal to the Connecticut minimum wage multiplied by 40, their weekly benefit rate under the law is going to be 95% of their average wage, whereas a higher earning worker would be eligible 60 times the Connecticut minimum wage. It's also important to note that employees can receive employer benefits for the time that they are out on FMLA. However, they cannot receive over 100% of their normal wages. So the result of that is that it won't be, more lucrative to be out on FMLA as opposed to reporting to work. And it is also worth mentioning too, that under the law, wages is defined broadly. So it can include salary and or hourly pay, vacation pay, holiday pay, tips, commissions, severance pay, etc. And wages from multiple covered employers may be combined to determine what an employee's rate will be. The law also contains a job protection provision. So employees who have worked for their employer for at least 3 months are entitled to job protection. So note that the employee, may be eligible for the paid benefit, but depending on the length of time they've spent with their employer, that job protection provision might not kick in for them. But I would note that, if they are taking the Connecticut FMLA benefit, that law does have an anti-retaliation provision. So the worker is afforded job protection coverage under that law, presumably.
And this is going to be one of those situations. So as Emily's talking about job protection, now anyone who is in charge of leave within their organization should be managing Connecticut paid family leave, Connecticut unpaid FMLA if you are an employer who is of a large enough size that applies, federal FMLA, ADA, and if it was a work-related injury, the workers' comp element. So just because an individual, recall, is going to be getting Connecticut paid family leave doesn't mean that you should not provide the federal FMLA forms to individuals for the time away, which is going to provide notice of that job protected leave.
Yeah, no, and so it's also important to note that there's a lot of intricacy happening here between all of the different laws that are available. So it can definitely get a little confusing. But this law in particular also has a notice requirement. So I do want to flag that for you guys, just because, I know we've heard about this law for a long time, but there is actually notice requirements that are starting in July. And the Connecticut Paid Leave Authority does have a poster available that you can use to share with your employees. But just know that that's coming in case you're not already providing that notice to new hires and your employees. So I did also, just while we're on this slide, want to reference, the changes that were also made to Connecticut FMLA. And a lot of those kind of mirror the changes that we're seeing, or the introduction that we're seeing with the Connecticut paid family leave. So Connecticut FMLA, the eligibility has been expanded to employers with 1 or more employees. Employees are now eligible to participate after 3 months. And the definition of a family member was expanded, and the benefit was changed from the 16 weeks in a 24-month period to now allowing 12 weeks in a 12-month period. So just good to kind of keep that in mind as you're kind of reconciling these two programs. Next slide, please. Great. So next, we're going to talk about minimum wage increases. So currently, the minimum wage in Connecticut as of August of this past year is $13 an hour. And you'll see on the slide that there are increases planned for 2022 and 2023. But what I did want to mention, although it is a ways away, 2024, Connecticut is shifting over to an economic indicator to assess the minimum wage. So the minimum wage is going to be published in the Employment Cost Index, and the U.S. Department of Labor is going to calculate that statistic, which will inform the Connecticut minimum wage. And this is relevant when we talk about the benefit amount under the Connecticut paid FMLA. So worth just being aware of in the coming years. Okay, so this next one, salary range disclosure. So under this new statute, employers are required to share the wage ranges of positions with new hires, internal applicants, and employees. Under the statute, wage range is defined as the range of wages an employer anticipates relying on when setting wages for a position. And it can include a lot. It can include reference to pay scales, previously determined wages for the position, actual ranges for the employees who hold a comparable position, or the employer's budget for a position. And this information has to be provided at very specific time. So it's important to be aware of it and kind of follow those requirements. So for applicants, you're either going to provide the wage range of the position when the applicant requests the information, or if they don't request the information, you're going to provide it at the time they're made an offer of employment or compensation. For current employees, employers are going to have to provide wage ranges to employees when they change positions within the organization or at the time of the employee's first request for the wage range for the position that they're in. So, this is going to be really interesting, and I think it can be difficult sometimes because it requires you to have a hard conversation with your employees if perhaps they look at the data and don't understand, where they fall. And that comes down to, performance or length of time in the position or what have you. I did want to also call out that, employees can bring lawsuits for violations of these requirements within 2 years of a violation. And the damages here are fairly extensive. They can get compensatory damages, attorney fees and costs, punitive damages, and other legal and equitable relief. And kind of coupled with that is a new gender wage discrimination standard. So the previous version of this language had referenced that employers cannot pay someone of the opposite sex for equal work. That has now been updated to reflect that employers cannot pay employees of the opposite sex less for comparable work. So it's really that difference between the word equal and the word comparable. And comparable just kind of feels like there would be way more comparisons that you could make to a court or to whomever in a wage discrimination case about what jobs are comparable versus equal. However, there are ways that you can differentiate your jobs as an employer. So, you have to look at skill and effort and responsibility within a position. And employers can also use geographic location as a differentiator, credentials, skills, education, and training as different reasons for why you would see different wages within that comparable jobs.
In the past, when we've advised employers to perform an audit of their pay practices to determine whether or not there is any exposure from an Equal Pay Act claim, we've had individuals and organizations look at different departments and then the individuals within that department and kind of up-down analysis as to who reports to who and what their job duties and responsibilities are based off of pay and earnings and those type of things. One of the concerning aspects of comparable work is it doesn't mean that they have to be doing similar things. Like, is it comparable in that both jobs require 2 years of previous experience in the field? This comparable, I know it seems silly that we're focusing a lot on one word, but this has created a lot of concern and heartburn within the labor and employment community because it's broader than other state statutes, almost every other state statute, and under the federal law concerning equal pay. So it'll be interesting as we move forward. I mean, this has only been in effect since October, so we don't have case law that's analyzing comparable, but we really are going to be relying upon the courts to give us parameters as to how to determine comparable work.
Yeah, definitely. And I think, looking at these two laws, it's definitely puts a lot of emphasis and spotlight on compensation practices. So anything internally that can be done to make it, to just kind of do your due diligence and see if there are any outliers or things that need to be remedied. I think it's incredibly important to be mindful of that. We can flip ahead to the next slide. So the next statute I wanted to talk about is the Crown Act. So this one was passed back in March of 2021, I believe. So I bet most of you have heard of it. But I did want to take a moment to recognize it as Connecticut is actually one of the first 14 states with the Crown Act. And for those of you who aren't familiar with the Crown Act, it stands for creating a respectful and open world for natural hair. And over the past several years, there's actually been a really big push by the Crown Coalition, which is a partnership between Dove and the National Urban League, the Color of Change organization, and I think the Western Center on Law and Poverty. And it's been kind of cool to watch this take off and get adopted by different legislatures. And the push around this legislation arose out of some pretty troubling statistics, specifically around Black women making reports that they were 1.5 times more likely to be sent home from the workplace because of their hair, and Black women reporting being 80% more likely than white women to agree with the statement, "I have to change my hair from its natural state to fit in at the office." So in effect, what this law does is it amends the Connecticut Human Rights and Opportunities Act to include physical ethnic traits associated with race to be included in the definition of race. And like I said, this law is now enacted in 14 states. And for those of you that have workplaces in Massachusetts, Pennsylvania, North Carolina, Michigan, and Wisconsin, there's actually legislation that's been pre-filed or filed there, and it's kind of working through each state's legislative process, but just something to keep in mind.
Action item, and Emily and I really try to make sure that you're able to leave this presentation with action items, is to do an audit of your dress and conduct code to make sure that there's nothing in there that could be read broadly as decreasing the ability of an individual to feel comfortable having their natural hair at work. If you are in an environment that has safety requirements where there'll be hair coverings or those type of things, make sure that it's clear that, you know, exactly what the requirements are, whether or not that a head covering will be required, but isn't set forth in such a way in which a violation of the Crown Act could be viewed. And I think that's most often what Emily and I have been seeing as concerning. In most situations, you very rarely are going to have situations where a hairstyle in and of itself is going to be cause for discrimination or for any type of disciplinary action. It really is when it's involved with safety or when it's seen as quote unquote unprofessional and it's used more as a determinator of this person won't receive this person won't receive a raise or they won't receive a promotion because they're not seen as professional enough. And one of these areas comes into play. So something to just keep at top of mind. We did get a question concerning the last slide. So if we could just go back to that last slide concerning pay equity. Do we anticipate audits of wage disclosures? And for instance, if the disclosure is given verbally, should employers be keeping track of it each time it's given? We don't foresee that there will be specific audits only to that fact, but we do foresee that when the Department of Labor comes in and does do an audit, that it's going to branch out. And if you're not doing this, that this is going to be considered a separate violation. We think it's highly unlikely that they're just going to come in for this reason, but instead it's going to be kind of a larger concern regarding unpaid time or improper classification or something to that effect. As to keeping track of verbal disclosures, it absolutely should be tracked. And that's not only from an administrative standpoint regarding if there's an audit from the Department of Labor, but also to protect us if litigation should ensue. In most situations, if we have a pay equity claim, we're going to be looking at a class action, and we're going to want to be able to show that we have provided information to people, that the information that's been provided is true and accurate, that it was timely provided at the appropriate periods of time. So definitely, if you're giving it orally, a written notice should be provided as well to indicate it. I do think a form of printed kind of disclosure to the employee is even more helpful so that it's more difficult later in defending the claim for someone to argue that we are hiding the ball. If we go back to the Crown Act, the most recent question is, does the Crown Act mention hoodies? And it doesn't. This is not an action concerning attire. Specifically, if an individual can state that a hoodie is religious in nature, you can, the individual may have protections for wearing the hoodie. Otherwise, the hoodie itself, if it violates the employee's, if it violates the employer policy, then it can be restricted. If they're indicating that they need a head covering of some format, but that it doesn't have to be a hoodie, if the head covering is based off of religion or some other type of practice concerning their faith or a belief system, then you could have additional protections. But a hoodie in and of itself wouldn't fall within the protected hairstyle or textures. And we haven't seen any case law that discusses hoodies as being specifically tied to one race or national origin. I know that the media has discussed hoodies and their relationship to people of color, but from a legal standpoint, there hasn't been any connection between the two, and that restricting the ability to wear hoodies is in any way discriminatory in a racial or national origin sense. So great question.
Great. So, the next one we're going to talk about here are COVID-19 recall rights for certain businesses. So, upfront, this isn't going to apply to everyone on the call. This is specific to hotels and food service contractors with more than 15 employees. But coming out of the pandemic, the legislature did enact a statute that creates a right to recall. And it's kind of like what you would see in a traditional collective bargaining agreement. And basically what it does is give laid off employees in these industries the first chance at jobs that are posted for the organization. So the employer technically has to offer these opportunities to their laid off employees before hiring a third party. Employers that choose to not hire back employees do have to provide them with written notice as to why they're not being hired back. And there are there is anti-retaliation language as well in the statute to protect employees that are exercising their rights under this law. And then we have an act deterring age discrimination in employment applications. So this law was set out to basically prohibit employers from seeking information on applicants' birthday and certain dates tied to, finishing a degree or what have you, to prohibit employers from getting kind of an indication of the age of the applicant at that phase in the hiring process. So what's important here is that it does apply to an initial employment application, but it does not prohibit you from asking that question later in the process. So what I would say is if you have like a background check process, it's okay if your applicant is filling out dates on that to validate a certain credential or something of that nature. But now on your initial application, you just want to make sure that you don't have any fields that are going to ask for that information when someone just goes and applies for a job on your website. And with that, I think that brings us to the end of our Connecticut statutes. So in short, a lot happened in Connecticut in 2021. But probably only more so at the federal level, which is now what Tanya is going to talk about.
So we're gonna pivot and talk about things that should be at the top of mind and on your agenda moving forward in 2022 and looking backwards at 2021 from a federal standpoint. And of course, unfortunately, we're still talking about COVID. So A quick update as it relates to COVID-19 and vaccination mandates. And I struggle with putting this first sub-bullet under vaccine mandates, just because I don't think that the OSHA 100 plus ETS was ever a mandate, since it did have a multitude of options, but I think the media has referred to it as a mandate, so we'll stick with that. So as most people know, last week, the United States Supreme Court stayed the ability of OSHA to enforce its emergency temporary standard for employers with 100 or more employees. Now, the United States Supreme Court didn't knock it down. I mean, it's still an ETS, but OSHA cannot enforce it. So the question becomes is, will OSHA withdraw the emergency temporary standard, or will they continue to attempt to fight in the Sixth Circuit to argue that it's within their authority and it should be enforced? The standard that the United States Supreme Court used in staying OSHA's enforcement of it is such that they had to take into account a belief as to whether or not it was within OSHA's authority to do so. I think most people presume that OSHA would withdraw the emergency temporary standard and maybe try to create a new one that fits within the parameters set forth by the United States Supreme Court, but that's still up in the air. But I would suspect in the next week or so, we're going to have a better understanding as to that. On the same day that the United States Supreme Court issued its opinion as to the OSHA ETS, we also got the determination for healthcare providers under the CMS mandate. Now, anyone who's working in healthcare is aware that the healthcare ETS that was in effect from June until December expired at the end of December. So we currently have no healthcare ETS. But we do have the CMS mandate that requires that all employees at a healthcare organization that receives Medicare funding must be vaccinated unless they're entitled to an exemption for religious or medical reasons. So that mandate was upheld by the United States Supreme Court. And then the third area that we've been seeing vaccine mandates is under that federal contractor rule. So those of you who do any form of work with the federal government, whether or not you're a prime contractor and you have a direct relationship, or you're a subcontractor, you're aware that President Biden's executive order 14042 provides that all employers are required to have a vaccine mandate with all of their employees being vaccinated. Now, currently, the federal contractor mandate is stayed, and it's stayed nationwide based off of a Southern District of Georgia decision that was issued on December 7th, 2021. Now you'll see though that my slide says split jurisdictional determination, and that's specifically because half of the states in the United States have a second stay that has been entered. So Kentucky, Ohio, Tennessee, Missouri, Nebraska, Alaska, Arkansas, Iowa, Montana, New Hampshire, North Dakota, South Dakota, Wyoming, Florida, Louisiana, Indiana, Mississippi, Texas, and Arizona all have a second stay that's been issued. Now, the only state that I just listed that's in New England is, or even the Northeast, is New Hampshire, right? But the reason it's important is because the Southern District of Georgia stay that was issued on December 7th has been appealed. So we're expecting a Court of Appeals decision on that matter. And if the Court of Appeals were to find that there was insufficient evidence to support the stay, that the stay was improperly granted, and remove it, then the federal contractor mandate would go into effect in all of the states that weren't additionally listed or don't have a second stay in effect. So the second stay for a lot of people may seem like overkill, but the reason for it is because then those states don't have to rely only upon the Southern District of Georgia. We do presume that once the Southern District of Georgia is ruled on at the Court of Appeals level, that it also will go to the United States Supreme Court, but that whole process is moving a lot slower than the OSHA and CMS mandate. So you're likely thinking to yourself, Tani, you've just talked for 5 minutes all about these vaccine mandates and where they stand in the court, but how does that help me from an operational standpoint, day in and day out? And the answer to that is that even if you're not part in the healthcare realm and you have the CMS mandate, if you're not a federal contractor who potentially at some point in the future could be mandated, you are still covered by OSHA's general duty clause. So you have a general duty or an obligation to provide a safe and healthy work environment to your employees. Over the course of the last 22 months, we've had limited guidance from OSHA that is industry-wide or across the country as to steps to take to protect workers and employees. If we then take the OSHA 100+ ETS, that's going to provide us with foundational information about things that we can easily be doing and accomplishing that are going to be found by OSHA to be helpful in protecting the health, safety, and well-being of employees. So the recommendation, if you don't have a COVID policy, you should have a policy in place. It doesn't have to be as broad and expansive as what OSHA was requiring under the 100+ ETS, but having a policy in place is important. The next element is making sure that individuals who have COVID aren't coming to work, right? That in that policy, you restrict the ability of employees who have COVID from coming into work and keeping them out of work. And at this point in time, I would then turn to the CDC. Based off of the CDC guidance that's in place at the time in which the individual is out of work, not returning them to work until recommended by the CDC. I would still continue to collect information concerning vaccination status of our employees. And I would do this so that you can appropriately follow the CDC guidance, which is different depending on whether or not you're unvaccinated, you're vaccinated over 5 months ago with the Pfizer or the Moderna vaccine, you're vaccinated over 2 months ago with J&J, or you've been vaccinated within the last 5 months, or if you've had a booster. I mean, when the boosters were added into the dialogue, it then created a whole different subsection because under CDC guidance, if you'd had the vaccination more than 2 months for J&J or 5 months for Pfizer and Moderna, you were going to be treated very similar to someone who's unvaccinated versus someone who's had the booster. So I do still recommend getting information concerning vaccination status because it's going to be necessary to follow CDC guidance as to time out of work or time in close contact. Masking policies are also going to be something that's going to be important. The OSHA ETS, the whole purpose of it was to protect only our unvaccinated workforce, which is why they focused only on having unvaccinated individuals wearing masks. I think that we're at a point where looking to the CDC again from a masking standpoint is going to be important. Whether or not that means any type of mask or N95s, I think that's a much bigger question. But what OSHA is going to be looking for if they were to do an investigation is really going to be attempts at providing a safe work environment. So really having the policy, keeping people out of work who are sick, attempting to social distance or mask, those are all going to be really important things. Another thing that we're seeing a lot of from a national question and standpoint is wage and hour questions related to COVID. Employers who may continue to have a vaccine mandate in effect, or they may not call it a vaccine mandate, but for employees who are unvaccinated, a requirement that they receive either weekly testing or monthly testing or testing in some format. There becomes questions concerning the location of the employee and whether or not there's compensable time and who is required to pay for the tests. So those are things that if you do have a COVID policy that requires testing in some format, that you're going to have to be prepared to answer based off of the jurisdiction in which the individual lives in. And this leads us to our next slide. And a lot of employees, continue to work remotely. And we have seen just this tremendous increase from a remote work perspective. So this graph, it's a Bloomberg graph, and it sets forth percentage of individuals who are working from home. And we see prior to the pandemic over here on the left-hand side of the screen, less than 10%. We had a very small group of individuals who are working from home. And now we're staying pretty even, a little over 40%, right? Now, this aspect is really important because it changes a lot about the policies and the practices that we as a company have and put into place. So let's jump to that next slide. So specifically for our remote employees, it's important to understand the rules concerning, so before we actually get into the employee mobility, we did have a question. Will COVID positive leaves that do not include hospitalization be eligible for CT paid family and medical leave? Unfortunately, I have that horrible attorney answer, which is it depends. So it appears as though there could be situations in which the conditions that someone has COVID and the symptoms are such that it would qualify as a serious health condition that's going to result in the individual being entitled to paid family medical leave. Our recommendation would be that if you do have an employee who gets COVID, without regard to whether or not they're hospitalized, that you recommend that they apply because it's going to be a case-by-case determination. And unfortunately, I think oftentimes when someone gets COVID, we're not sure what the next couple of days or weeks are going to look like. So instead, making sure that they're given, that opportunity and the ability to receive that benefit at the onset would be important. And then on a case-by-case basis is where we're going to see things. Recently, the Department of Department of Paid Family Medical Leave kind of did do a webinar kind of discussing this, and it was unclear. It's a case-by-case determination, and they didn't lock themselves down as to that element. Recall though too that if someone has COVID but is still able to work from home, so if their symptoms are such that they're still able to work, they're not going to be entitled to that paid family medical leave in most situations, and most likely it would then be determined to not be a serious illness if they're able to continue to work in that sense. From the work from home challenges specifically, one of the big things we want for people to keep in mind, because I think it's an easy thing to overlook, and even when we were working in person and all together, was something that often had issues, are I-9 policies and appropriately completing I-9s for our remote work employees. Recall that if an individual is working remotely and you're onboarding them remotely, the employee holding up a copy of their green card or their birth certificate or so whatever documentation they have and holding it in front of the camera is insufficient. You need to have somebody who is an agent of the organization or employee who can physically see the document and verify its authenticity. That might be a third part, depending on the location of the employee. It might be that you ask them to come into one of your locations, that you hire a third party, or we've had some situations specifically during the pandemic where another family member is treated as an agent for the organization and certifies the veracity of the documents that are being provided, and then they're scanned and sent over for the file. But you need the original and someone acting as your agent at the initial stage. So understanding that, with that significant increase in work from home, having a remote work policy in place is extremely important. One of the elements that is being discussed most often and that previously was missing from remote work policies is provisions or restrictions on the states in which employees can work from. So if you're a Connecticut employer, your operations are all based in Connecticut, you're likely attempting to attract and retain employees. And if you're like most of the other organizations across the country, it's tough. It's tough to attract and retain people. So you might have increased your market as to who you're going to, especially since so many people can work from home. Understand that if you do hire someone who is living in another state and they're going to be working from that state, that there is going to be tax implications to that determination, and you may need to register to do business as an organization within that state. In addition to the state implications, there could be workers' comp and unemployment implications as well. So the first thing is understanding from a hiring standpoint where the individual is working. We've seen a lot of organizations, however, that once people went remote, they presumed that people were going home to work, when in fact people were going to stay with children to watch grandchildren, or they were going to second homes, or they bought second homes, or all these different things. And come to find out, even though people thought the person was in Connecticut this whole time, come to find out they're at their ski home in Colorado, or they're lying by the pool in Palm Springs. So knowing where your employees works is important, and potentially considering putting limitations on the states in which individuals can perform work from home, other than if they're traveling or it's a de minimis trip in some format, but truly kind of setting up and working from a location is something to consider. Safety and security implications are two other things that should be kept at top of mind. From a safety perspective, making sure that the work environment is one in which the individual can safely perform the job from an ergonomic standpoint, that they have an appropriate setup where you're minimizing eye strain and other issues that could occur in a work from home standpoint. From a security standpoint, making sure that you have confidentiality agreements and other agreements in place with the individual that will protect your data and information and the data and information of your clients, customers, or consumers is really important, because if there is a severance of the relationship, you're going to want to make sure that those individuals aren't able to walk off with your information concerning operations, and whether use that against you, simply find yourself in a situation where the integrity of the data is called into question, or use it to compete with you. Additionally, one of the other reasons why it's important to understand and know where your employee is working from is for electronic monitoring standpoints. A lot of organizations are now questioning how much are people really working. I'm paying them for 40 hours, but I think they're only working 20 hours. Can I log onto their computer and look through their camera? Can I what can I do? First, having provisions within your handbook about the ability to monitor network use is important to give notice. Second, however, knowing where the individual is operating from is extremely important, because this is going to be a state law question. We're going to review state laws concerning electronic monitoring in the employment realm. So truly understanding where the employee is working from, where their quote unquote home office or work from home setup is really an underlying factor that needs to be taken into account. The third aspect concerning work from home and employee mobility and traveling and those type of things are wage and hour implications, specifically for your non-exempt employees. So I think a lot of us are experiencing situations where non-exempt employees are sending emails outside of normal work time. So maybe the normal work time is 7 to 3 or 9 to 5, and you find non-exempt employees who are sending emails at 8 at night or 10 at night. And when you talk to the employees, you say, hey, what's going on? And they respond something to the effect of, I just want to start the next day clean, and it helps me sleep better if I know what's in there and I've taken care of everything, and don't worry about it, it's no problem. But the problem is we need to be compensating employees for that time, because recall that under the wage and hour laws, the statute requires suffer or permit to work. Now, an employee suffers to work between 9 and 5, their regular hours, but they're permitted to work in the time in which we have knowledge that the individual is providing services, even if we aren't quote unquote requiring that work to occur. So those individuals, that time spent should all be compensated. So we need to make sure that we have in place a way, one, for employees to record the time, and two, a way for managers to track and make sure that they understand the working hours of their non-exempt employees. Another key element is expense reimbursement from a work from home model. And this is going to be dealt with specifically as it relates to the location in which the individual is providing services. So if you have an employee who's working from home in California, the rules are going to be different as to what expenses need to be reimbursed versus the expenses that would need to be reimbursed under Arkansas or Connecticut law. So please keep that at top of mind. The last thing from a national standpoint that I want to just briefly discuss is the National Labor Relations Board and changes or evolution that we're going to see in 2022. Now, for those of you who are in a non-unionized work environment, you're probably thinking, okay, I'm done, I'm checking out, but please hold on a few more minutes, because the things we're going to be talking about here apply not just to unionized workforces, but also non-unionized locations. So earlier this week, the National Labor Relations Board indicated that they were going to start seeking public comment on a number of different pivotal decisions that have occurred over the course of the last few years. So during Trump's administration, we had a very pro-employer National Labor Relations Board. With Biden, we're foreseeing a much more employee-friendly board. Under President Trump, there was very few situations and instances in which public comment was requested as to different decisions that were entered into. But this year, on the agenda, National Labor Relations Board has targeted over 40 Trump-era decisions that they're going to be reconsidering. And these are 5 of probably the biggest areas that we're going to see reconsideration of. Employment status would be the first one. This is going to be the determination and the standard for determining whether or not a worker is an independent contractor or an employee. The second one, and the one that's biggest for our non-unionized clients, is going to be legality of workplace rules. Recall that in 2017, we had the Boeing decision that the then Trump NLRB found that Boeing's restrictions on the ability to record in the work environment were legitimate. That was overruling an administrative judge's decision that such a rule violated Section 7 rights. And recall that Section 7 is going to be the employee's ability to participate in protected and concerted activity concerning terms and conditions of employment. Under past Obama era rules, very specifically, the National Labor Relations Board had said in the Whole Foods case that employees have to be allowed to take video at work, that it's protected activity. We then have Boeing saying you can have a workplace rule that protects confidential information and that limits the ability to record. This is something that's gonna, is coming up again in this board, and that they're seeking public comment on. We're also, they're seeking public comment on, and we'll have decisions concerning the appropriateness of smaller bargaining units, the availability of consequential damages, and then finally, confidentiality clauses in arbitration agreements. And the confidentiality language is something that we're seeing not just from the NLRB standpoint, but also at a state law level, where we're seeing an increase in legislation across the country that restricts an employer's ability to require confidentiality, not just in arbitration agreements, but also in separation agreements and in settlement agreements with employees. And while previously in California specifically, it was limited to claims concerning sex discrimination or sex harassment, we're seeing a much broader evolution of legislation that restricts the use of confidentiality clauses in a multitude of different situations regarding arbitration agreements or more general claims of harassment or discrimination. So that is what we can expect from the National Labor Relations Board in 2022. We have a couple of minutes left, and we are happy to answer any questions that you may have concerning any of the topics that we discussed today. Emily, any final parting words for our guests?
No, I don't think so. I would just thank you all for coming, and I hope it was informative. So please join us again next month.
Yes, thank you all very much. We hope that you and your loved ones stay healthy, and we wish you all the best in the future. And again, just as a reminder, next month, we have the second in our series concerning the annual update. And that is going to be a presentation by Elizabeth Smith and Elizabeth Johnston concerning romance and relationships in the workplace. And that's going to be on February 17th at 9:30 a.m. So thank you all.